Hello and welcome to the 24th episode of our No Worse Off Restructuring podcast series. I'm Lindsay Hingston, head of our London restructuring team and one of your regular podcast hosts. And I'm joined today for his third outing on the podcast, Alex Thomson, a senior associate in our global restructuring team.
Thanks, Lindsay. Great to be back.
So today we're returning to the topic of liability management, which remains a hot topic in Europe. And specifically, we're going to be looking at the expert evidence of Lord Neuberger and Dame Gloster, which has been submitted in the US proceedings on Selecta. We've done a number of podcasts already that touch on similar topics. So I'll refer you all back to our podcast on Selecta and Hunkemoller, where we kind of set out what had happened in the transaction as far as we understand it. And we're not going to go through that again today. We also did a podcast back in 2024, which was, again, Alex and I talking to Georgina Peters, a barrister at South Square, about the proper application of a Senegon in the context of LME, which is definitely going to be in the frame during the course of today's discussion. So Alex, do you want to take us through the context of the current debate?
Yes, thanks, Lindsay. And so, as you say, we're not proposing to go into the facts of the Selecta transaction, which we've covered in detail in previous episodes. Instead, we'll be focusing today on the debate between Lord Neuberger and Dame Gloster, who are both providing expert opinions as evidence in the ongoing Selecta litigation in New York. And I guess, as is evidenced by our previous podcast discussion back in 2024 on the Senegon case, which you also referenced, legal advisors in our market have been discussing and disagreeing for years about what the impact of the minority protection principle on majority decision-making powers in the LME context is. And so, for the nerds among us at least, it's fascinating to see this debate play out in litigation proceedings between two English law heavyweights. That being said, though, it's important to note the context in which this debate is taking place. So these experts, Lord Neuberger and Dame Gloster, are debating a matter of English law, but they're doing so in the context of providing expert evidence in New York proceedings. And that's because those proceedings, those New York proceedings, include claims related to alleged breaches of an English law governed intercreditor agreement. The expert reports are being provided in that context to assist the New York court on those questions of English law relevant to the New York proceedings. But it's important to note that regardless of the outcome of the New York proceedings, in other words, regardless of whether the New York court accepts Lord Neuberger's or Dame Gloster's position as to the correct English law position, that has absolutely no impact on what English law is.
Yeah, and I think that is a point that people should very much so hold in their mind, because you can see how a decision of the US court on this will be seen as kind of quite big news, and I'm sure will be big news for Selecta either way. But I think we're going to have to be quite careful not to see that as a read across, because fundamentally we need to know what the English law position is and what the English courts think about this. And I think what the debate is laying bare is that this is a fairly unsettled area of English law. It's why there's a lot of interest in it. It's why this principle is getting cited in a number of the LME cases that are currently being litigated, including Hunkemoller and Hurtigruten. And those two cases actually are both in the early stages of being challenged in front of the English courts. And we understand that the Senegon principle might be in play. So we may not have that long to wait until the English court has its say on this again. We think that the arguments we're going to discuss today, so the Neuberger and Gloster opinions, will form the bookends potentially for how this debate is going to play out in front of the English courts when next it's before them. And it may be that the decisions made by the New York court in relation to this evidence will have some impact on market practice. So to come to the crux of the debate, the argument being had in these expert opinions is rooted in the minority protection principle, or variants and umbrella concepts for it under English law. We're going to use the term minority protection principle throughout, but it has to be said that neither of the experts are particularly happy with that terminology. So Lord Neuberger disagrees with that description of it, but uses the term nonetheless. And Dame Gloster uses a different term, which we'll come on to. But we're, just for the sake of simplicity, going to use minority protection principle. It's an established and a long-standing principle under English law, and it requires that a majority, when exercising powers conferred on them to bind a minority within a class, have to act bona fide in the interests of the class as a whole, and not in a way which is oppressive or unfair to the minority. So this often comes up in the context of finance documents, of course, because they are littered with majority powers: the power to amend, the power to waive, the power to instruct enforcement, which is what's an issue in this case. And so this principle comes into play. And there have been a few cases, not many, but a few cases under English law where the principle has been considered squarely in that context. So in the context of complex finance documents, and Senegan itself was a case in point. As a very quick reminder, that was a coercive bond exchange. So it was all around the consent, the exit consent mechanism under the bond. As far as we are aware, there has not been an English case that has considered the issue specifically in relation to the power to enforce under an English law intercreditor. And that does have potential implications for how it applies in this case, as we'll come on to.
Thanks, Lindsay. And before we turn to the expert opinions themselves, I think it's just helpful to provide a few disclaimers. The first is that, as you'd expect, both of these expert opinions, and indeed Lord Neuberger's rebuttal, are inevitably detailed, but also nuanced. For the purpose of this discussion, we'll try and represent the points simply, which may mean, of course, that some of the nuance is lost, and our apologies to Lord Neuberger and Dame Gloster for that. The opinions also cover a lot of ground, but we're going to focus on specific points, namely in relation to the existence, nature, and application of the minority protection principle. And finally, our goal is to summarize and explain the legal arguments. We won't be expressing a view on which way it will go, and we are reserving, of course, our position on that. I think it's helpful to start by distinguishing a few questions relevant to the debate in the context of Selecta, and indeed any other transaction where a majority acts to bind a minority. The first is, what is the content of the minority protection principle? The second, what is the nature of the minority protection principle and when does it apply? And the third is, applying those to the facts, does it apply and has it been breached? The crux of the debate in this case between Lord Neuberger and Dame Gloster is around the second question, i.e. nature of the principle and when does it apply, although they also diverge on the third question, which was application to the facts. In short, Lord Neuberger contends that the minority protection principle can only be implied into a contract. In other words, it is a term of the contract itself, albeit not expressly written. And it's important to note that in English law, the courts are slow to imply terms into contracts. So the application of the minority protection principle as an implied term of the contract is immediately narrowed. And one of the central limitations is that it can only be implied, if not excluded, or otherwise inconsistent with the express terms of the contract. Dame Gloster, on the other hand, argues that it is a much broader or more fundamental principle. She argues that it forms part of the English law proper purpose rule and is an incident of the power itself. In other or plainer words, a power must be used for the purpose it is given and not for some improper purpose.
Okay, so if we pause there then and think about what is the practical implication of those differing views, which in terms of the legal reasoning of how they have got there, are really very distinct. They're starting from very different places in terms of their understanding of what this principle is and the legal grounding for it. But what does that mean in practice is what we're most interested in. So with Lord Neuberger, the majority protection principle will not apply in all cases because it won't apply where it's either expressly excluded by the parties or if it is inconsistent with the express terms of the contract. For example, because the contract already has a regime for the matter in question. For Dame Gloster, the majority protection principle, or at least requirement that the majority has to use its powers for a proper purpose, will always apply over and above any terms of the contract. She says it's doubtful whether it can ever be excluded by contract, but in any case, it could certainly only be excluded by the clearest possible terms.
Yeah, and there's clearly a stark contrast between these views, and the potential sort of ramifications of the differences should not be overlooked. And looking at Selecta to illustrate the point, Lord Neuberger's position seems to be, at least, that because the intercreditor agreement includes a detailed framework for how the majority could exercise its power to give enforcement instructions, there is, in effect, no room to read in a further constraint on the majority's power. If that's correct, and it may well be, then it may follow that the minority protection principle has no place in any English law intercreditor agreement, at least not regarding enforcement actions taken by the majority, because these agreements inevitably include a detailed regime setting out when and how enforcement instructions can be given. And if that is the case, then for obvious reasons, that's a fairly significant outcome. Dame Gloster, on the other hand, says that regardless of the detailed mechanics in the ICA, regarding how or when enforcement instructions can be given, the majority is still bound to exercise that right for the proper purpose, which she says in Selecta was to enforce the security so that it could be distributed among the senior secured creditors on a pari passu basis.
Yes, and importantly, that proper purpose test, according to Dame Gloster, sits behind the power. So the power is inherently limited by it. And that functions, as I said earlier, as a separate and an additional constraint alongside any contractual limitations. So Lord Neuberger doesn't disagree with Dame Gloster on the fact that a contractual power must be used for its proper purpose. But his point is that the contractual purpose must be derived from the terms of the contract, taking into account both the express terms and the implied terms, which takes us back to his arguments about this implied term. So he dismisses Dame Gloster's argument that the proper purpose is anything other than what is expressly set out in the intercreditor. And this intercreditor had a defined enforcement objective, which was to maximise, to the extent consistent with a prompt and expeditious realisation of value, the value realised from the enforcement.
I think it's worth just saying there, Lindsay, that that's consistent with most English law intercreditor agreements.
Yes, indeed. So I agree. This would certainly read across the market in that respect. But where does it all lead us? So Lord Neuberger says the minority protection principle is an implied contractual term, and in Selecta, there is no room for it to be implied or read into the intercreditor. This is because the contract already has detailed restrictions on the use of the majority's power, which are focused on minority protections, so you don't need anything else. Anything else is excluded. Dame Gloster says the minority protection principle, or proper purpose rule, as she calls it, is a broader legal principle, which curtails the use of any contractual power to bind others. And in Selecta, that proper purpose was to enforce the security so that it could be distributed among the creditors on a pari passu basis. So how then do they apply that to the facts in Selecta?
Well, in short, Lord Neuberger simply says that the enforcement instructions complied with the very detailed provisions set out in the ICA and were therefore valid. As is hopefully clear by now, he does not consider that the minority protection principle is one of the conditions which had to be complied with in Selecta, because, as we've said repeatedly, he says it should not be implied into the ICA. That said, he argues that even if the principle did apply, it's not clear to him that the Selecta transaction could be said to breach it. His argument here is that even if Dame Gloster is correct that the minority protection principle or the proper purpose rule applies on the terms that Dame Gloster argues, which she says is to enforce security for the pro rata application of proceeds among creditors in the same class, according to Lord Neuberger, that requirement was complied with in Selecta. He says that because in Selecta, each senior secured creditor received its pro rata share of the 30 notes and was entitled to participate in the exchange of those 30 notes into the 10 notes. And so he argues that any difference in the ultimate outcomes or treatment of the minority creditors flows not from the enforcement action or the exercise of majority powers, but rather from their own decisions to accept or deny the exchange offer.
So that last point is interesting, and it's certainly the question that many of us in the industry have been focused on when considering Selecta. So our understanding of what Dame Gloster is saying is that the aim of the majority, when looking at the transaction as a whole, was to split the class of otherwise pari passu creditors for the majority to receive a better outcome than the minority. That, she says, was the improper purpose and in contravention of the ICA. And there's a bit of an echo there of a debate that we've seen play out in other restructuring contexts around whether, when you're analysing an LME transaction, for example, do you just look at a particular step in isolation, or do you look at the entire arrangement and its effect more holistically than that? So we've had that debate in the context of schemes, where the English court tends to take the view that it's going to look at the wider arrangement. It also played out in the Westco and Cora case in the US, which was looking at New York law, to be clear, not English law. But the argument was run that you had to look at each step in isolation, and in isolation it was all fine. And the court said, no, you have to look at the thing as a whole. And when viewed that way, they struck down the transaction.
And so perhaps to try and wrap up, what does all of this mean for the future of European LME? And on the one hand, as we said at the beginning, perhaps nothing, because the outcome of the Selecta case in the New York proceedings, as we said, is not binding English law. But then, as Lindsay also said, it's likely, or at least possible, that the outcome of this case in New York would impact market practice. But looking at the arguments themselves, And as we've already mentioned, they are starkly different arguments with significantly different consequences, depending on which way the argument, the sort of debate ultimately lands. But if Lord Neuberger is right, then as we have said, it seems difficult to see how the principle, the minority protection principle that is, could ever apply to enforcement where there is an all singing, all dancing ICA, as is typical in almost every funds transaction in Europe. But the answer may be different where you're looking at different majority powers, which don't have the same comprehensive regime built around them. For example, the power to amend finance documents. And this is one of the ways that Lord Neuberger distinguishes the Senegon. If, on the other hand, Dame Gloster is right, then the principle will always apply, but the proper purpose may differ depending on the nature of the power in question. In other words, it should not be taken that the pari passu requirement is universal to every majority power just because it is said to be in play in relation to enforcement.
So I think, just to finally conclude on it all, one of the few things they do agree on is that the scope of this principle is not clear, and it's very much so still an evolving area of law in England. For that reason, I'd imagine this is not going to be the last time that we return to a Senegon, or my guess is even Selecta. So thank you, Alex, for joining me today. Thank you also to the client who actually suggested that we do this as a podcast episode and try and provide a bit of a clear summary of these expert opinions, which hopefully we've managed, although I have to say they are, as Alex said, kind of quite difficult, nuanced opinions. So we've tried to boil that down as best we can. And thanks everybody for listening, and please do tune in again for the next episode.